taking our motion.
All right. Let's go on the record, please. Court calls case 2020 CF 578, State of Wisconsin versus Burnell Edward Kelly. Appearances, please.
Joel Hermansky appears for the state, appearing in person.
Attorney Angela Shodak appears for Mr. Kelly. Both Mr. Kelly and Attorney Shodak appear by Zoom.
All right, Burnell Kelly, can you hear and understand me, sir?
Yes.
All right, so this matter is before the court for hearing on the defense motion, post-conviction motion to vacate the convictions, I believe, on counts 2 and 3 and 4, and to set aside for a new trial. Matters have been briefed by the parties. Essentially comes down to an argument that trial counsel, Attorney Jeffrey Yeager, ineffective, failing to cross-examine Antoine Leverett, that's Leverett, who was the only eyewitness called regarding the July 10th incident, which formed the basis of the convictions for Mr. Kelly. As the argument goes, Mr. Everett reportedly had indicated that to police during an investigative interview that the incident had occurred in the evening. Potentially nighttime, and that at trial his testimony changed, that he indicated that the incident occurred in the morning hours, 10 a.m. to 11 a.m. or thereabouts. And the argument is that trial counsel was ineffective in not cross-examining Mr. Leverett on the inconsistencies in the statements he gave to the police, prior inconsistent statement he gave to the police, the statement he made in court. So I have reviewed the parties' brief. The state has objected, and I think it's just helpful to begin any analysis like this. And how I see today's hearing, unless parties disagree, is whether the motion or post-conviction relief, I believe the defense agrees with this, ultimately is sufficient and sets forth sufficient grounds to order a Mockner hearing, because I think that's our first step, is whether this should go to hearing or not. And you're not automatically entitled to do that hearing. So standard set forth, and I think this is the case that I'm going to rely on here today, probably do a quick side of it just to make sure there's no issues. Give me a moment. I don't believe there is. It's out of my research bank, but it's always good to have updated case law. State versus Valiette, 336 West 2nd, 2011. 2011 West 79. No developments on that case since I last looked. It's a good practice. I don't think the standards have changed, but I never like to rely on a case that's long. Valiette is fine. In any event, in that case, the Wisconsin Supreme Court went through the standard to a review that a court applies as it relates to ineffective assistance. On this case, that case was ineffective assistance of post-conviction counsel, but standard and Strickland is that the criminal defendant is guaranteed the right to effective counsel, that a convicted defendant must show two elements to establish that counsel's assistance was constitutionally ineffective versus that counsel's performance was deficient. Second, that the deficient performance resulted in prejudice to the defense. The defendant does not show the first element simply by demonstrating that counsel is imperfect or less than ideal. The court has made it clear in the Constitution a defendant is entitled to reasonably effective assistance by a reasonably competent attorney. Thus, the court looks to whether the attorney's performance was reasonably effective considering all the circumstances. Reasonableness of counsel's conduct must be evaluated on the facts of the particular case, viewed as of the time of counsel's conduct. Benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. So that was at paragraphs 22 and 23 of that decision. A defendant may not presume the second element, prejudice to the defense, simply because certain decisions or actions were made in error. Rather, the defendant must show that particular errors of counsel were unreasonable and that they actually had an adverse effect on the defense. And this, too, is an inquiry requires a court considering the surrounding circumstances. An act of omission that is unprofessional in one case may be sound or even brilliant in another. Proper test for prejudice in the context of ineffective assistance of counsel claim, therefore, is whether there's a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Reasonable probability is a probability sufficient to undermine the confidence in the outcome. Importantly, counsel is presumed to have rendered adequate assistance in the bounds of professional judgment. The court must be vigilant against a skewed perspective that may result from hindsight, as it may not second-guess counsel's performance solely because the defense proved to be unsuccessful. Counsel's decisions in choosing a trial strategy are to be given great deference. The court in Strickland went so far as to say strategic choices made after thorough investigation of law and facts relevant to the plausible options are virtually unchallengeable. Even decisions made with a less than a thorough investigation may be sustained if reasonable, given the strong presumption of effective assistance of counsel. That was all set forth in Valiette. So, moving forward and applying those standards to this case. The challenge here, I think, is one, as I've read both parties' briefs and the reply brief, is to determine whether the original petition and reply over the hurdle of provide a sufficient basis to prompt an evidentiary hearing. What troubles me about what's been filed to date is it's a microcosmic view of the case. So we take the testimony of Antoine Leverett, and I think you have to begin there. The defense tells a story, I think, of how a very simplistic story that Antoine said it was the morning, and he did at one point in his testimony. If you read later in his testimony, I'm not sure it's that clear as to when it occurred, when he says it occurred. He definitely said evening to police, but you'll see in his testimony, he's all over the place in terms of the two events. One was in August, I believe August 2nd or thereabouts. There's a second incident. It's an August incident, which formed the basis of some of the charges. And then there was a August 2nd, correct. And then there was the July 10th incident. And he talks about night at some points when says he's talking to the police. Convolutes the 10th and the 2nd of August incidents. At least it's unclear when I read through portions of the record last evening. I don't know that it's as simple as the defense portrays it, and I think it's incumbent upon the movement to address the trial record, which in this case, respectfully, the movement really doesn't. You take two little microcosmic statements and say the defense counsel was ineffective for not cross-examining Mr. Leverett on the inconsistency. Well, the inconsistency has to be plain on the record, and I don't know that you've established that through references to the testimony, and the entire testimony of Mr. Leverett, I might add. And that is concern number one. Concern number two, relative to the ineffectiveness of counsel claim and whether you've met the hurdle to get a Mockner hearing, is that, again, it's a microcosmic view. There's 3 days of trial transcript, including Mr. Kelly's testimony and his denials that this incident ever occurred, which the defense does not address at all in its submissions. There's the totality of this is a totality of the circumstances. This isn't just a small snapshot of the case. And again, there was testimony of a probation agent. We had the GPS results and so on. And the evaluation, I think, has to be on the record as a whole and the defense strategy. And I don't think you can just simply look at Antoine Leverett's testimony without looking at what else happened in the trial. And try to put it into context in terms of saying, why was this a strategic decision? Was it not? One of the things that crossed my mind as I read this is I did go and look at Attorney Yeager's closing. Attorney Yeager's closing focused on a couple things. One is that Mr. Kelly said this never happened, strangulation, the battery, the disorderly conduct. And secondly is that Mr. Leverett was just incredible, period. He took the strategy of saying, well, Mr. Leverett claims that he's watching Burnell choke his close friend and strangle him, and then he and his friend Doug say, let's hit the road. And Attorney Yeager focuses on Burnell's denials and focuses on the incredibility of Leverett's testimony. And he even gets into points that defense counsel here does, that Leverett doesn't even get on the record. He calls him Bernard, not Burnell. But whether that decision to not cross-examine him on the timing, I don't know that the defense has established under the totality of the transcript that was sufficient, and at least certainly hasn't done it on, I don't think, to a sufficient factual level for the court at this point. We had Officer Smith that testified. He took the statement from, I believe it was Burnell. Excuse me, I believe it was Mr. Leverett. We had, again, the probation agent. We had Mr. Kelly's testimony. Mr. Kelly's testimony was that it never happened, not when did it happen. So that all being said, I do have my concerns relative to simplified point is that Attorney Yeager did not, I don't believe, cross-examine specifically on time. But again, it's just hard to tell. You have to look at a bigger context, and I don't think the defense motion does that. It just takes one little microcosmic view of it, at least from my review of this record. And I've not gone through everything because that's not the court's job. Is not to read 3 days of trial transcript. It's the defense's job to direct the court to the facts that support the ineffectiveness claim. And get to hearing, I think one of the questions becomes, again, what record would support having a hearing on this at this point without looking at it in a bigger, more global perspective. This was a whole trial. Mr. Kelly wanted to test, as my recollection, you can check the trial transcript, but I even recall in the forfeiture by wrongdoing, Mr. Kelly was very anxious to testify. So I don't know what went on behind the scenes, and he says it didn't happen again at all. So that's problem number one. But even if we assume, and I would note, I do think defense counsel is right to point out that challenging the credibility of witnesses is the art of cross-examination, not only the art of cross-examination, but also a critical part of trial counsel is showing inconsistencies in the unbelievability of Mr. Leverett's testimony. And I do have some concerns, but again, when I went through Mr. Leverett's testimony, he says he saw it. May have given a different time, but was the failure to cross-examine him on that in the totality of his testimony, which refers to all different times and people and all of those things, and it appears Attorney Yeager made the decision to attack his incredibility that two grown men would leave a room while their friend was being strangled by Mr. Kelly. That's a strategic decision he appeared to have made, and I don't think any of this was addressed in the initial filings, which is concerning to me. On the second prong, as to whether, a couple things. As to the prejudice, the defense, again, I don't think you can view this just as in a conclusory fashion as the defense has, and simply say, well, we've met our burden to get a hearing. It had an actual adverse effect on the defense. Again, Mr. Kelly testified where he was, what he was doing, when he was released from jail. I mean, none of that's taken into consideration by the defense motion. There's no consideration of the closing. There's no consideration of Officer Smith's testimony. There's no consideration of a lot of things that went into this trial. And think without that, it's just simply at this point more speculation and conclusory statements by counsel. Result, reasonable probability sufficient to undermine confidence in the outcome. Mr. Kelly said it did not happen. The victim never testified. She came in and had the motion forfeiture by wrongdoing, which I think was ultimately denied, but she came in and said she didn't remember anything. So that was what that record said. But you can look at Attorney Yeager's closing. He attacks Mr. Leverett and Mr. Leverett's credibility and says it's just his entire testimony is bunk. Maybe not for the reason that the time changed or allegedly changed, but for reasons that it was entirely incredible. His entire story was incredible. The other aspect of it that the defense motion, the linchpin, and Attorney Shodak, you can correct me if I'm wrong, the linchpin of this is that, oops, my Zoom just went down. Off the record.
Light on the cover of your laptop that's flashing.
I know.
So clearly you have power. I
have no idea what just happened. Okay. So glad that CCAP helped me out. I mean, this thing, I told him my computer's failing. What I got. It's showing battery's dead. And it's not charging.
at this point.
All right, go back on, please. Can't explain that. All right, we're back in the record after power failure. It's very Chodak. What I was getting at is, with respect to the back side of this, this error, if we assume it occurred, actually had an adverse effect on the defense. Isn't that dependent on this event having occurred after 9:48 p.m. when Mr. Kelly presumably returned home according to the GPS, July 10th?
No, Your Honor, I don't believe that it's dependent on that. That was the alibi was meant to address that, but I don't think that the motion, the post-conviction motion here, relies on something that specific. The issue is more about Mr. Leverett's testimony and the inconsistencies of that testimony than about what specific time this may or may not have happened.
Okay, but in terms of, so he says evening, I mean, it has to have an actual, or excuse me, reasonable probability is a probability sufficient to undermine the confidence in the outcome. And under the facts of the record, though, doesn't the facts show that if this was evening, it could have been evening as well? I mean, how does, and I know there's an inconsistency that that you have raised. Again, I'm not sure, and again, I think you need to look at all of Mr. Leverett's testimony. He says in response to Attorney Lehman, morning, But then later in his testimony, he starts talking about evening again. And, you know, I'm not sure it's as clear as you're portraying it. And perhaps your point is, well, then you should have asked him which one was it. But wasn't the whole defense theory here that this never occurred?
Yes, Your Honor, and that's why the motion was phrased and the claim was what it was Mr. Kelly isn't saying, well, this happened a different time than Leverett says it happened, and we need to get into the timing of it. Mr. Kelly has never said that. Of course, as the court is aware, Mr. Kelly's position is that this just never happened at all. So the only reason the time matters is as it goes to Leverett's credibility. So if somebody can't remember, so to speak, whether or not something happened, at night or in the daytime, then one would need to question, well, are you just making this up then? Because if this really happened.
Isn't that what Attorney Yeager did? Didn't he say he made it up? It was entirely incredible?
Yes, he did say that he made it up, Your Honor, and he gave some reasons, as Your Honor indicated earlier, why the testimony was incredible in Attorney Yeager's view, and of course in others' view as well. But that doesn't mean that was enough. Our argument is that the inconsistency of the time is something concrete that can be looked at. It can be shown by police reports versus what Leverett said in the testimony, and there's no dispute whatsoever that it's different. Whereas whether or not somebody...
That's what I'm asking you, though. Is it really? Did you read Leverett's testimony?
Yes, sir, and I know...
I read it last night. I don't think it's as clear. Later in his testimony, it seems to waver.
I disagree, Your Honor. He does mention the words evening in his testimony, but a reading of that, my reading of it was that when he was talking about evening during his testimony, he was talking not about the issue in question, but he was talking about when he gave his statement to police, which was a different time and date. So he didn't give his statement to police the date that he says this happened. He gave his statement to police on a completely different day. And on that date, when he gave a statement to police, that statement was given at nighttime. And that's what he was saying during his trial testimony.
Okay. So with respect to let me take a step back. You talk about Mr. Leverett. Assume that Mr. Leverett was aware of an alibi defense. What evidence is there of that?
There is none, Your Honor. We don't know whether he was aware of that or not. So, the motion wasn't relying on his knowledge. The mention of the alibi was just something that if the trial attorney had questioned Mr. Leverett on the inconsistencies, then presumably defense counsel would have given a reason why it mattered. And that was one reason why we believed it mattered. Specifically, not that we're speculating that he knew, but there's really no other reasonable reason why he would have changed his story in that way. Why does somebody change their story from night to day when there's really no reason to do so except for this alibi? So if Attorney Yeager had cross-examined him on that, perhaps we would know the answer to that, but because he didn't, we don't know, and that's probably another reason why he should have asked those questions.
So your theory is that had Attorney Yeager cross-examined Leverett on the time change, that it is material and under the case law enough to meet the standard for this, that it actually had an adverse effect on the defense.
Yes, Your Honor. And with respect to Your Honor's issues earlier with not having brought in the rest of the testimony and the entire trial, there's case law, and I wasn't prepared to argue this, so I don't have the case law at my fingertips, but I think it's pretty common, commonly cited in ineffective assistance of counsel claims that to prevail on an ineffective assistance of counsel claim, a person doesn't have to show that their attorney was completely unprepared, was completely a terrible lawyer, was completely incompetent, that the attorney could have performed completely perfectly well in all ways except for one. And if that one is strong enough, then everything good that the attorney did doesn't matter, because we're not saying Attorney Yeager's a terrible lawyer. We're not saying he's a ridiculously incompetent person. We're not saying any of that. We're just saying this mistake was ineffective assistance of counsel, this one thing. And while it may be only one thing and one aspect of the entire trial, which was long, it was important because it's not as if there were 18 eyewitnesses and this one guy just happened to make a mistake or lie in his testimony. There was only one. There was only one person who claimed to be an eyewitness, which is what magnifies this one issue to be something large, whereas in a trial with multiple supposed eyewitnesses, it might not be that big of an issue. And that's where the totality of the circumstances, as Your Honor was discussing, I do believe that that is taken into consideration here, because the totality of the circumstances is there may have been many other witnesses, but none of them claimed to have seen what happened. Only Leverett did.
But my concern is this: if we're going to attack Yeager, doesn't it have to be some consideration of why he may or may not have gone into this based on Leverett's actual testimony and the totality of the testimony at trial, in terms of whether this meets the standard that the particular errors were unreasonable and actually had an adverse effect? Don't we have to look at actually, meaning, don't you have to look at the whole trial? I'm a little bit, if you say there's case law that we could just take this microcosmic view, you didn't cite it. In fact, there's not much in the way of law cited, but my concern here is, before we go to a mocker, is I began looking at the rest of the record, whether I think you have to look at Yeager's theory of the case, and it seems to me it's just taking this very microcosmic view. I share your concerns in a very rudimentary sense that if this timing was missed, that it was certainly a proper and appropriate subject of cross-examination. Just not sure it's as simple as you reflected that it is in your brief, considering the rest of the facts in the case. I don't think you can just pull it out and not look at the context of it. I'm generally in favor of ordering Mockner hearings, just because I think having a hearing on a matter is always beneficial. But my sense is here that the motion itself needs to be more robust, certainly as it relates to adverse effect on the defense, and particularly in light of the testimony of Mr. Kelly.
This isn't even.
I don't know if attorney, and I haven't had a chance to look at the rest of the transcript, but I think we need to look more. I think we need to look a little bit more broadly in the motion does. What's the state's position on this?
There's one of my observations is this: if we were to have a hearing, Attorney Yeager may establish some of the background information and his explanation for why he did or did not ask the questions he did. But I don't see this becoming.
Hang on a second. Really loud in the background. Whoever's at S9, stay muted, please. Joe's Galaxy. Thank you. Go ahead.
Don't see any more helpful information coming to defense from the testimony. The transcript is the transcript. The questions or lack of questions are what they were at the time of the trial. The closing argument remains. there's always an ability to go back and suggest there could have or should have been an additional question or issues. But as the court has already noted, there has been closing arguments challenging Mr. Leverett and saying that in whole cloth he should not have been believed. I don't believe that an additional question or two questions even concerning Mr. Leverett in cross-examination would have made the difference. I don't see where a hearing is in any way going to be helpful to defense, nor where the burden has been satisfied by defense to get themselves to an evidentiary hearing. So for the summary reasons that the court has identified, I don't believe there's enough here for a hearing.
All right, so here's what I'm going to do. I think, Attorney Chodak, I think your approach to this, at least at this juncture, I have a lot of concerns about the record itself, and that would directly relate to some of the facts and surrounding circumstances. I don't think you've done enough to get to a Mockner, particularly on second factor, because you've offered really no explanation, I don't think, show in light of what was argued at trial. I don't think you can just pull this out and say, well, if we would have cross-examined Leverett, the result would have been different, without looking at what Attorney Yeager did bring out, what Burnell Kelly did testify to, what the probation agent referenced, and the entire constellation of facts to say this matters, or at least address those facts. And the problem here is I have at least in my eyes, and it puts the court in a sort of a compromised position, in the sense that I don't know that it's incumbent upon the court necessarily to then have to take this motion and try to figure out and follow the defense argument as to why this omission mattered. That's where I'm struggling. We talk about some of the facts that you reference on Mr. Leverett's testimony, but even what I pointed out is some of the conflicting facts. It would have been helpful to have a presentation of Mr. Leverett's entire testimony, demonstrate that he was not, that this was, you said it was plainly inconsistent. When I read it over last night, I'm not so convinced, although now that you've argued that, I'm a little bit more, I would want to look back at it again, because Mr. Leverett's testimony is difficult testimony. Mr. Leverett, by the way, did not change his story as to what happened. The best argument you have is that he changed the story as to when it happened, and then it has to matter. Now, it may go directly as credibility, and that's where I think you do have a point. But does that, first of all, Attorney Yeager's decision not to question, if he made that decision at all, I guess we can figure that out in a Mockner hearing. But at the end of the day, does that get you to the prejudice hurdle? And can you just focus on, District Attorney Mansky just said, failure to ask, 2, 3 questions, whatever it may have been, in light of the entire record and the manner in which the case was presented. When you talk about he changed his story, for example, you say notice of alibi was filed, Leverett inexplicably changed the story, that it no longer happened, that is suspicious. I don't know how that was going to come in at trial, by the way. I'm not sure I think that would have required the prosecution to have coached Mr. Leverett to change his story based on a notice of alibi. Whether and a notice of alibi in a way that would have inculpated Mr. Kelly, which it really didn't necessarily. That was my point about the 9:48. Mr. Kelly, this could have happened in the evening. He was out. So I don't think it's as simple as you've indicated. I have my concerns. When I first read your submissions, I had my concerns. I probably still have my concerns. But I think there needs to be some supplementation of the areas that I've identified based on the actual record and or case law presented to the court saying that you can look at it microcosmically like you're saying. Because I don't think you could say this is, I don't think you can jump to the conclusion, and that's basically what the state says in its brief, is this is all conclusory stuff, Judge. You don't have to do anything with it. In a sense that there's some merit to that. Must be a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. Reasonable probability is a probability sufficient to undermine confidence in the outcome. I don't think there's facts that have been brought out looking at the trial testimony as a whole to demonstrate that. I'll give you the opportunity to do that. Now, you could say I don't have to, and then give me some case law that says you don't have to. But at this point, I think that motion needs supplementation. I think the fact, the basic theory you had coming into this goes to the credibility of a key witness, and of course that's important. But I don't think it's that simple. I think you have to look at the totality of Leverett's testimony, explain why it's so clear as you're saying it's clear. Look at, again, I didn't look at perhaps, I don't remember Officer Smith's testimony, that you was an investigating officer. I don't remember what other witnesses, and then just look at how Yeager argued this and what he did. And perhaps there was a strategic choice, and maybe we need to have him explain it. But I think you have to do more to get there. And I think that requires a more comprehensive analysis of the alleged error. Even if I assume it's an error, I think you've shown enough from the factual record to demonstrate to the court that you're entitled to a Mockner hearing. I'm not going to deny this outright because I have my concerns. Credibility, to your point, is a major factor, and especially if it's the key witness. But the theory of the case is that Mr. Kelly was never there and didn't do it. Then perhaps Attorney Yeager decided that cross-examining a witness who was just going to simply cement that Mr. Kelly was there and did do it wasn't a very good idea, even though the time difference was there. I don't know. But I think you have to take into consideration more than just what has been done, and whether at the end of the day, considering the totality of the facts here, it's mattered. And whether through the testimony of others and the totality of it, that that meet the second prong of the Strickland test. I'm looking at another case It's State versus Phillips, 322 West Second 576, 2009 Court of Appeals case, citing State versus Bentley, 201 West Second 303, says a motion claiming ineffectiveness of counsel does not automatically trigger a right to a Mockner testimonial hearing. No hearing is required if the defendant fails to allege sufficient facts in his or her motion. The defendant presents only conclusory allegations or subjective opinions, or if the record conclusively demonstrates that he or she is not entitled to relief. I can't say at this point the record conclusively demonstrates you're not entitled to relief, but I do think this is conclusory, and I do think you need to present more facts in the context of all this as to why it matters. And I'll give you the opportunity to do that. I share your concern from a very microcosmic, simplistic level that the alleged time change was present. But again, after I read Leverett's testimony, I wasn't as convinced as I was after reading your brief. And I think those are the things you need to address and present to the court. So I can determine, I tend to go forward with evidentiary hearings on these matters, but I think at this one you haven't done enough to get there, and I'll give you that chance. And I suspect the Court of Appeals, I want to do this on the record. I'm not going to read, I don't think it's fair to ask the court to read 3 days of testimony to explain why you can't do that. I think it's incumbent upon you to show that through the testimony, this was the linchpin and had the capability under case law and authorities that I've cited of actually impacting results. Particular errors of counsel actually had an adverse effect on the defense. That means the defense, not just this one little thing. I'm reading again, the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper function of the adversarial process, the trial cannot be relied on as having proved the just result. I don't think you've gotten us there, and I think it's the lack of facts that caused my concern on that. So I'm not going to deny the motion now. I'm going to take it under advisement. Allow you to supplement, address the court's concerns, and I'll decide if we're going to have an Ochner hearing. Or to give me case law that says I should ignore the rest of the record, which I suspect doesn't exist. But I can't tell you that I went out and looked for it because I don't think, again, it's just so much I can do on this thing. So I'd like you to supplement, and then I can better look into this.
I will do that, Your Honor. What would the deadline be for that?
When would you like? You could get extensions to the Court of Appeals, correct?
Correct, Your Honor, yes.
So you tell me.
Given my current caseload, I don't think I could realistically address this without at least a 60-day window.
60, did you say?
Yes, sir.
Yeah. Any objections from the state?
None. There is a victim, no rights exercised to date.
Okay. Yeah, and this is important stuff. And again, I think it's important I give you this chance and the reasons I've set forth and my concerns. If you want through September 12th, that's fine.
Thank you, Your Honor.
If you need more time to get it right or to get it to address this, I certainly send a letter to the court before the deadline. I'm always willing to work with counsel. And then the state, I presume, is going to want some kind of response thereafter.
Likely. I'd like to wait and see what the submission is, if and when it's filed.
So you want to do a status conference after the submission is made, and then we can figure out if you want to reply? We could. I have jury trials just throughout all these speedy trials. I don't have a lot of time to figure this out. Give me a second. What if we did 8 o'clock on the 23rd of September, although we may have another jury trial. I don't know if you're going to have anyone to... Yeah, 8 o'clock, September 23rd, for a status on what, for state's reply, that gives the state... Wait a minute. All right, so I'll give the defense to the 19th, and I'll give you the week, and then you can tell me if you want to reply at the end of that week. So 8 a.m., September 23rd, status on state's reply, and I'll give the defense another week then to file its brief with references to the record. All right?
Yes, thank you, Your Honor.
Probably a little more long-winded than you want, but that's unfortunately how I roll sometimes. So I apologize for being so long-winded, but it's important, and I want to make sure my concerns were clear. So anything else from the state?
No, thank you.
All right. Anything else from the defense?
No, sir.
All right. Mr. Kelly, you've been able to hear and understand things